to the merits and the attack on that, this court made factual findings, draw inferences from circumstantial evidence, and had the benefit of observing the witnesses upon which I made credibility findings. There was nothing indicated to me, in my view, that would indicate that there is a reasonable prospect of success on appeal. Consequently, the applications for leave to appeal, insofar as it relates to Mr. Apollos on the conviction, is refused. And insofar as it relates to Mr. Van Rijn and Ms. Smith, it is similarly refused. Thank you. I shall now turn to the issue of the Section 204 witness. Ms. Lombard, you must listen attentively as to what I'm going to say, as it has certain consequences. I explained to you before you started your testimony in this matter what the law says about a Section 204 witness. So that included the first stage of your preparation, your right to legal representation, and the process that was going to be followed in court. You explained that in the event that you comply with preconditions in the Act, that you will be entitled to be granted an indemnity for prosecution on the charges that I've mentioned to you. Those charges were, and I'm going to summarize it for you, a count of human trafficking, with various alternatives, and then a second charge of kidnapping. I promised you that in the event that I find that you answer questions frankly and honestly that is put to you, that you will be discharged from prosecution in respect of those offences. So now the time has come where I will tell you what my view is. Because as I understand the law to be, it is a decision that the trial court must make. And because it is a subjective test, it depends on me and how I feel about it. Properly applying the legal principles. But it is ultimately the decision of the court, having regard to various factors that I'm going to try and explain to you. Now, before I get that, I need to make a few comments. It was raised in the last 2 days that I should have dealt with your application much earlier. Meaning, immediately after I had given judgment on the 3 persons that were accused. You were not present at the time. But also, you might or might not be aware that the trial had taken a certain route and it was litigated in a particular way. After you had testified and you left the court precinct to wherever you had gone, a lot of other evidence was presented. And when a court looks at the evidence, you look at the evidence as a whole. Also, in the main trial, the 3 accused persons did not testify. From my experience, it often happens that when it comes to the sentence stage, then new evidence arises, particularly where the accused did not testify in the main trial. Hence, I decided to deal with this issue only after sentence. As you heard yesterday, I was not inclined to deal with your application unless you have legal representation. And that is why Mr. Van Tonder argued on your behalf yesterday, for which this court is indebted to you. I will not today repeat all the arguments. You would have realized that in the process of the argument, I was referred to a number of court cases. I will not repeat them to you. I'm well aware from the evidence that was presented, your level of education and your social standing in life. And I want you to understand what it is about. Now, this process where a person can testify for the state, having been a participant in the commission of a crime, serves an important purpose in the criminal justice system. It gives the opportunity for the state to successfully prosecute participants in a crime with the assistance of a co-accused. It is primarily a tradeoff and a deal that is being made. It is in order for the state to achieve their objective of getting a conviction, which they would have had difficulty and often unable to do but for the assistance of the witness. And for the witness's side, the benefit is that you might be indemnified by helping the state. In order for the state to make that decision, various factors are taken into account. One, the seriousness of the offense. And the involvement of the particular person that would be a potential witness. You will recall that when you testified, questions were asked to you about some of the things that I'm now mentioning to you. The state must decide what is the relevance and what is the importance of the witness's testimony. Coupled with that, what would be the collateral consequences? It's also important to note that through this process you are in witness protection. Because there must be a guard against any reprisals against the witness for offering their assistance to the state. It has two legs. One, the witness will come and admit complicity, and the community will see that person as but another guilty person. And secondly, where this process is most helpful, will be in organized crime cases where the life of the person becomes endangered by the co-conspirators. In their decision to come to that conclusion that the person may be used as a witness, various other factors like age and so on is taken into account. You will also realize that both with Mr. Van Tonder yesterday and Ms. Lombard today, Ms. Swanepoel today, I'm making that same mistake again because I'm speaking to you, Ms. Lombard. We engaged on the issue of what the state's ability would have been to get a conviction, especially for Ms. Smith, who was regarded as the kingpin here, if you didn't testify. So the deal I spoke of is a trade-off. Now let me explain to you how I want to approach the question of whether you have satisfied the requirements to qualify for an indemnity. A lot of criticism was raised against you. At trial, during cross-examination, and here in the last 2 days. It is expected of me that I must find my way through this cloud and the dust that's being kicked up. And in considering this question, I also want to look at it purely as a common sense approach. Often, as in your case, a person that has something to hide in the beginning does not come clean. You might lie, as you did, because you expected that 1,000 rand. It might sound little to many people. I saw your living conditions myself. I was there at your house at the inspection. I heard the evidence of your drug use and abuse over a prolonged period. R1,000 rand was a lot of money for you at the time. And you needed to feed your drug habit. You were so desperate that you had to go to Ms. Smith often to beg for food for your children. I cannot ignore that. You left school in primary school and had a hard life. I'm glad to see that you look much better. You had no encounters with the law before. You had no understanding how to deal with authority. How much weight do I then place on your reluctance at the outset to come clean? I suggest it should not carry that much weight. I told you I was going to approach it from a common sense approach. And I spoke about this deal that you reached. It is a process. It's seldom that a co-conspirator or participant in a crime come out with everything in the beginning. It took you a period of 7 months between March and October. That was your arrest, your statement to Captain Celia, and your ultimate statement that became known as the 204 statement in October of 2020. And of course we also know that prior to your arrest, your version was different. There was an agreement that nobody should mention the name of Mr. Van Ryn. Hence, Mr. Apollos and Ms. Smith didn't say anything on the 19th and 20th of February. It was you that made the first slip up from their perspective by saying he was there. Just shows the progression as you go along. We were told, and it's not evidence, but it came out in cross-examination also, of this process and to and fro between the investigating officer, your advocate, Van Tonder at the time, and how that statement was eventually arrived at. And how the version grew and was adapted and corrected as you go along. I'm now being asked, because of what happened before you took the witness stand, to use that to come to the finding that you were not honest with the court. I'm of the view that that approach is wrong. Up till that point that I cautioned you, you had the right not to incriminate yourself. And, as indicated, there's nothing strange about the progression to the truth. So it would be unfair to attach too much weight to what happened before the person became a witness. Having become a witness, the court will have to evaluate the evidence given. Now you will recall that I asked you a number of questions, often to the point where you would admit that either you made a mistake or that you lied in the past. But does that mean you did not answer the questions posed to you in court, frankly and honestly? Having regard to all the human frailties and the condition of the courtroom. I cannot ignore the fact that in itself, being a witness, and particularly in the High Court, confronted by heavyweight defense counsel and the intimidating atmosphere of a courtroom, that it is easy to trip up. What I can say about you, Ms. Lombard, that you owned up to your mistakes. Always. The decision I will make today will not be accepted by everyone. There will be people that will criticize me for the decision on both sides of the divide. That's not the test. I indicated to you at the outset, it is my decision of how I evaluate you as a witness that testified in this case. And in evaluating that evidence and coming to the conclusion, one should be very careful not to nitpick unnecessarily. If courts do not approach the whole system of Section 204 seriously, and too lightly refuse to grant indemnity that was promised to a witness, that might also undermine the criminal justice system in itself. On the other hand, it should not be used as a tool for people that commit criminal conduct to hide behind. Hence, the decision for the prosecution to utilize this tool and request the court to apply it must be considered carefully. There's two things happen. The witness has to forego a fundamental right. And yes, there are protections in the Act that the evidence given, if a witness does not get indemnity, may not be used against that person. But it might be a little, too late. As it is the court's decision to determine the question, to my mind, the court can take into account the demeanor of the witness. Having regard to all the considerations that was so lucidly set out by my sister judge in the Free State, in the Kayla case, and confirmed by the highest court in our country, I'm of the view that you should be granted indemnity. And that indemnity should be granted for the following offences. That is a contravention of Section 4, read with all the other relevant sections of the Trafficking in Persons for the Purpose of Exploitation Act, and all the alternatives that thereto under Section 10 and its derivatives, read with 11 that you were cautioned of. Should also be indemnified on a charge of kidnapping, in respect of Joshlin Smith, and any of the competent verdicts on those offences. This decision is arrived at after consideration, in particular, your part in the offense, which is the following. You were aware that the arrangements were made and said nothing. But that's not an offense. After the incident happened, you kept quiet as to the commission of the offense and went along with the story that was told by the others. Over and above that, you played no active role in either the trafficking or the kidnapping of Joshlin. So before I conclude, Ms. Lombard, did you understand that? So you may not be prosecuted for these offences that I've indemnified you, and you will be served with a copy of the order. It will be in English, but at least it was translated to you in Afrikaans now. Good?
As the court pleases.
Thank you.
As God pleases.
Ms. Swanepoel, we will email you the order tomorrow because it's typing it up and then editing, because we need to get the indictment. Do you maybe have the indictment in electronic form?
I do.
Send it to Mr. Broad, please, so that we just copy everything in. Thank you. I'm indebted to counsel for your assistance. And my last part of this case. Nothing more for me to do.
All right.
You can say so long. I'm going to adjourn in a moment. We're done. If people want to leave, they can leave. I just want to switch off my device.